Okay, please be seated. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Anthony Elizalde. This is a criminal case. Anthony Elizalde is charged with aggravated assault with a deadly weapon. The definition of aggravated assault with a deadly weapon will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Anthony Elizalde in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our justice system. Before proceeding further, it will be helpful if you understood how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence is presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anybody, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research on the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify court personnel of the violation. During the course of the trial, the court may take recesses. I will change that and say the court will take recesses. And you will be permitted to separate and go about your personal affairs. That actually doesn't apply to today because we're going to be staying here through the conclusion. But we will be taking recesses, and you're not going to take a break to go down the street or whatever. But we will be taking regular breaks throughout the afternoon. During these recesses, you must not discuss the case with anybody, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask the person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. You cannot have any cell phones, tablets, laptops, or other electronic devices in the courtroom. You may use those devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or to communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. At the end of the case, while you are deliberating, You must not communicate with anyone outside the jury room. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, television, or any other computer, cell phone, internet, or any electronic device, or any other means to get information related to this case, or the people and places involved in the case. This applies whether you are in the courtroom. Well, in this case, it'll only be while you're in the courthouse, because we'll be staying here until this is concluded this afternoon or this evening. You must not visit places mentioned in the trial or use the internet to look up maps or pictures, etc. Jurors must not have discussions of any sort with friends or family members about the case or people and places involved. And so do not let even the closest family members make comments to you or ask questions if you talk to them during one of the breaks. In this age of electronic communications, I want to stress again, I've already said it 3 or 4 times, that you just must not talk about this case face to face or talk about it using any electronic device. You must not use computers, phones, electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on the internet, chat room, or blog. None of that today, please. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you might find. That is contrary to our judicial system, which assures that every party has the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. Obviously, a mistrial is a tremendous expense and inconvenience to all the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both, which we sure it will not take place today. In every criminal proceeding, a defendant has the absolute right to remain silent. And no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant does not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said if they had been permitted to answer. During the trial, it may be necessary to confer with attorneys out of the hearing,
Hello,
out
this
of
is
your
Chris
hearing, out
Norman
of
at
the
Bulldog
jury's
Bail Bonds.
hearing,
Our office
to
is in
discuss
Crestview,
matters that
Florida, but we
require
serve.
consideration by me alone. It is impossible to predict when such conferences may occur or how long they will last. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. Lastly, before the attorneys have an opportunity for an opening statement, the court needs to instruct you with regards to note-taking by the jurors. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you don't want to. That will be left up entirely to you individually. So you can do it or not, it's up to you. So you will be provided, as you just were, with a notepad and a pen for your use if you wish to take notes. Any notes you take will be for your personal use only. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes, including myself. And I do that personally before I leave the building tonight. If you take notes, please do not be so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence. And you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. So, with that, the parties, beginning with the state, may make an opening statement.
Thank you, Judge. Good afternoon. Thank you for being patient with us. This is a really important part of our system, and we really do thank you for being a part of this today. The state expects that you're going to hear about some events that took place on July 26, 2022. The victim, Erica Kotz, and the defendant, the state expects you're going to hear, are in an on-again, off-again relationship. The state expects that you will hear that Ms. Kotz was helping her friend move and using the Toyota Camry that the defendant owns, but she frequently also uses to help her friend. Defendant then contacts her and is wanting the car back. And her friend decide that instead of bringing the car all the way back to where Mr. Elizada is, that they will drop the car at the nearest public place for him to come get, which is the ball fields in Shalimar, just by the sheriff's office headquarters. They make it back to the house in order to do that. Previously they had been, I believe, the state believes so here, they were either getting food, pulling in from getting food, or the victim was pulling out of the driveway to go drop the car off where she had decided to drop it off when Mr. Elizada pulled into the street where her friend's new house was. The state expects that you'll hear the victim testify that the defendant then made eye contact with her and floored his truck at that Toyota Camry that she was actively driving. and that she had to swerve into her friend's yard to avoid being hit. The state believes that you'll hear from Miss Terry Hamilton, who's her friend, who's going to corroborate those events. And you're also going to hear from Sergeant Roberts, who's going to tell you about the physical evidence that was at the scene and tell you just generally the results of the investigation. At the end of the evidence, the state will ask you to find the defendant guilty of aggravated assault with a deadly weapon without intent to kill. And again, thank you for your time.
Does the defense wish to make an opening statement?
Yes, Your Honor.
You may proceed, sir.
Please support. Counsel. Good afternoon. What we expect the evidence to show is that we agree with the state that it's an on-again, off-again relationship. My client asked for his car back, and that Ms. Cox became very upset. Not just upset, became angry at him. And days before, I think it was 4 days, something of that nature, she told him that she was going to be on Fawn Lane. And he tells her, well, look, because she didn't want to tell him where the vehicle was. So he tells her, you know, I'm going to the sheriff's office. But he decided before he goes to the sheriff's office that he was going to go check this Fawn Lane out and see if they're there. He pulls up into Fawn Lane, and there's going to be some controversy in the evidence. Either she was pulling out or starting to go or something. But my client pulled on Fawn Lane, stopped, and she said, I'm going to the ballpark. She tucked off into the ballpark. Now, realize the ballpark's probably only from right behind the judge, maybe, to the windows, through the double doors. So you're talking like a very short distance. Really, there's Miss Hamilton's house, and then a lot, or maybe a little fence, and then the ball field. I mean, it's that close. She parks the car. My client drives around the block, parks almost next to her, gets out, and Mrs. Cox, she's out the car, sees him pull up, starts getting her stuff from the trunk, puts it on the ground, hands him the keys, and they leave. You're also going to hear a voice message, I expect, from Ms. Cox. And I don't really want to get too much into the evidence, but let the evidence show what it does. But it contradicts what the state just said about my client trying to hit her. Ladies and gentlemen, we ask you that after carefully weighing and considering the evidence, that you come to the only lawful conclusion in this case, and that's not guilty. Thank you.
So who does the state wish to call first?
Your Honor, the state's first witness is going to be Erica Cox.
Madam Clerk, would you please swear the witness?
Please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Please be seated and talk to that mic, ma'am. Counsel, you may inquire. Pull that mic up to you, ma'am. That mic right there. There you go. Talk right into it. Thank you.
Yes, sir.
Good afternoon. Can you tell us your name and how it's spelled, please?
Erica Cox, ERICAKOTZ.
And Ms. Kotz, do you know an Anthony Elizada?
Yes, I do.
How do you know Anthony Elizada?
I dated him for 6 years.
Okay. And were you involved in an incident also involving Mr. Elizada on July 26, 2022?
Yes.
Okay. Can you tell us where this incident occurred?
It occurred on Fawn Lane in Shalimar, Florida.
Okay, and what county of Florida is that?
Okaloosa.
Okay. And can you tell us what happened?
Yes, ma'am. I was helping my girlfriend Terry. We went to her new house on Fawn Lane, and we were pre-cleaning before we can get her in there. We decided to break and go get a little lunch at Saxby's, and that was when Anthony arrived at my house to, I guess, do my yard work. However, he did not call and notify me or let me know of this, so I was not home. This agitated him, and he made contact with me over the phone, where a argument began to take place back and forth. And he was demanding that I provide him the address as to where I was at. I would not do that, but I did let him know I was on my way. Well, upon returning to Terry's house on Pond Lane, I get into the vehicle to go to my house. And when I backed out of the driveway and looked to my right, that is when I noticed Anthony turning on to Pond Lane.
Mm-hmm.
When he made contact and locked eyes with me, that is when he began accelerating on the gas. There was a boat trailer and a truck that was impeding the right side of the road, which is where I would have to drive on and exit. There were children behind me, and he was positioned in the middle of this road, facing me head on. He gassed it, accelerated, was coming at me, was not slowing down, and I needed a way to get out. So I veered off to the left through Terry's grass, and instead of going home at that moment, I decided that wasn't a wise choice to bring that energy back to the house. I was fearful, and I wanted to get to the ballparks, which is the most public place I could get to.
Okay, so let's slow down a little bit. So you were pulling out of the driveway.
Yes, ma'am, I was.
Okay. Is this street wider or narrow?
It's a narrow residential street.
Okay, so it's narrow already,
Yes, ma'am.
in addition to the things that were in the road impeding
Correct.
you being able to go around. Okay. What kind of car were you driving?
I was driving a 98 Toyota Camry.
Okay.
White one.
Is that car titled in Mr. Elizada's name?
Yes.
Okay. But you were going to return the car, but
Absolutely.
Okay.
Yes.
made the decision to go to the ball fields instead. Is that
Correct.
correct?
Instead of at my house.
Okay. How did you feel when what was Mr. Elizada driving? What?
A Nissan Titan.
Okay. How did you feel when he accelerated towards you?
Scared to death.
Okay. After you swerved through, and what's your friend's full name?
Terry Lynn Hamilton.
Okay. After you swerved through Miss Hamilton's yard, what did you do after that?
That is when I drove immediately across the street from Fawn, so I crossed Fawn Lane, left Fawn Lane, crossed 6th Street, And this is the most public place I could go to. There were people on the ball fields as well as some workers. And I began to unload the belongings of my grandson out of the trunk of the car onto the parking lot, the ground, essentially.
Okay. Did Mr. Elzada eventually come and get that Toyota Camry from where you had left it?
He did. He circled the block and pulled up from behind me while I was standing at the trunk. He pulled up at an angle, got out of the vehicle, and stood next to me. And I asked him to back away. I didn't feel safe. And I was getting the rest of the belongings out of the trunk of the car. Once I was done, we exchanged some words. He got in his truck, and I began to walk in the opposite direction towards my house.
Okay. Did you end up going back to your house?
No, not.
Okay. Where did you go?
I looked over my shoulder back to see what was happening, and at the time I couldn't tell who was standing at the truck. He was engaged in a conversation. What I understand with Terry, some more exchange of words, and while she was on the phone with 911, and then he drove off away from the ball fields. And that is when Terry got a wagon, picked up those belongings, took me home, to her house.
And where did you guys go?
We went to Terry's house on Conley.
Okay. Do you have any idea if the police ever made contact with Mr. Elzada that day?
No, ma'am. No, I had no knowledge of that being done.
Okay, did you see the police in the area?
I did. I went outside to have a cigarette at Terry's house, and I did see the police circling the area, and that's when the police see Anthony attempting to enter the vehicle that I had left for him with the key fob and the key. He was trying to enter by other means other than the key.
Okay.
And that's when the sheriff's department pulled up.
Did Mr. Elzada stay in the area with the Toyota Camry, or did he leave?
He left in his Nissan Titan. My Camry stayed at the ball fields.
Okay.
At that time.
Okay, so did you make contact with the police that day?
I did, but it was later that afternoon. It was after after he had already driven off.
Okay, so how did you make contact with the police?
Apparently, I had left with Terry again. We went to Lowe's, picked up some chemicals, and upon returning, I was notified by neighbors at Anthony.
Did not object to your say?
Approach.
Hold on, wait.
7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Ms. Cots, did you make contact with Sergeant Roberts that day?
Yes, I did.
Okay. How did Sergeant Roberts make contact with you, or did you make contact with her?
I made contact with her. I was looking through the bushes, and that is when I noticed that Sergeant Roberts was across the street. And I went and I waved to her, and that is when she radioed that she had located.
So you got her attention?
I did.
Okay. Did you know what Sergeant Roberts was doing across the street at the ball field?
I guess, I don't know for sure, but what it appeared is.
What did you observe?
Oh. I'm going to sustain the objection. Would you re-ask? Make sure.
What did you observe with your eyes Sergeant Roberts doing prior to her getting you getting her attention?
She was.
Objection.
You may.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
You may continue, counsel.
Thank you. So, Ms. Cox, after you made contact with Sergeant Roberts, what occurred? Did you write a statement? What occurred?
She asked me what had happened, what had transpired, and I let her know what had just went down as far as Anthony coming at me with his vehicle. I was very fearful.
If you need a second, you can take a second, Ms. Cox.
It was after, I didn't know what happened. It was filled out a statement.
Ma'am, do you need to take a break?
Sir.
Okay, take a deep breath. Okay.
Yes,
If you need to take a break, let me know. But if not, go ahead and be comfortable before you answer. Go ahead.
So you wrote a statement for Sergeant Roberts,
yes,
and is that all you did as far as this incident and investigation?
yes.
Okay. Ms. Cox, is Anthony Elzada in this room today? And if he is, can you tell me where he's sitting and what he's wearing?
Yes, he is. He's behind you, over your left shoulder.
I'm sorry, you're going to have to speak
He's
in the... I'm so
behind
sorry.
over your left shoulder.
Okay, and can you tell me where he's sitting?
Across from me.
Your Honor, please let the record reflect that the witness has identified the defendant.
Court so notes.
Your Honor, I don't have any further questions for Ms. Cox at this time.
Thank you. Does the defense have any questions?
Yes, Your Honor.
You may.
Ms. Cox, this vehicle you're talking about, this Camry, you said it was titled in my client's name. There's actually another person on the title, isn't there?
That's correct.
Okay. And my client asked you several times where the vehicle was, did he not?
Yes,
And you didn't want to tell him, did you?
I was not going to disclose my location for the safety as well as my friend.
Okay. All right. And because you wouldn't, my client told you he was going to the sheriff's office, didn't he?
Yes,
Okay. And you became pretty upset, didn't you?
I did.
sent him some pretty ugly text, some words, did you not?
Yeah.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street.
Okay.
Call 850-683-1045.
You sent him some pretty ugly text, didn't you? And you're angry.
Yes.
And he didn't reply back in the same, did he?
Not via text, no, sir.
Oh, okay, all right. And to kind of set it straight a little bit, when he turned onto Fawn Lane, and where the driveway is, it's relatively close to the ball fields, isn't it?
Yes, sir.
I mean, maybe to where the white part of the window where the judge is to maybe the other windows, if that, right?
Yes, sir. That's correct.
Like real close.
She is on the corner, so yes, all I have to do is cross 6, but where the driveway is further in.
Very short distance. You'd agree with that, very short distance.
Yes.
Okay. And he stopped his truck, did he not?
No, sir. That's why I drove off through the grass.
Okay. So you're saying you didn't tell him that you were going to the ball fields?
No, I had asked him to meet me at my house.
Okay.
And that moment, when I chose to go to the ball fields, that was while I was in the vehicle.
So your answer would be no, you didn't tell him to go to the ball fields?
No, sir.
Okay. Now, when you backed out of I'll say your driveway, actually it's Miss Hamilton's driveway.
Yes.
When you backed out of that driveway, Miss Hamilton was actually going the opposite direction, was she not?
Correct. Towards my house.
Okay. So her back would have been where this was happening, would it not have been?
I'm sorry.
Oh, yeah, okay. Well, if she's driving this way, and you're headed that way, her back would have been towards you, would it not?
No, we were back to back, so I'm facing this way. She's driving opposite behind me.
Well, yeah, that's what I mean. You're going the opposite way. And maybe we're turning it around, but we're both saying the same thing. You're going one way,
Correct.
she's going the other way,
Sir?
right?
Yes, sir.
Okay. And you're clear about that?
Yes, because I asked her to pick me up at my house.
Okay. Now, when you stopped at the ball field, my client pulled up like, I don't want to say seconds, but pretty close, right?
Yes, sir.
Okay. He didn't ram this Toyota that you were in, his car, did he?
He did not ram the Toyota.
Okay.
Because I drove off through the grass, avoiding it.
Okay, then, and at the ballpark. He didn't hit the Toyota then either, did he?
No, he did not. He pulled
Okay.
up behind.
Now, if she wants to clarify the question.
Yes, sir.
And when he got out of the vehicle, he didn't threaten you, did he? Didn't raise a hand to you?
He did not. But he
Didn't call you any-
threatening by way of intimidation.
Didn't call you any names?
Yes, sir. Not at that moment.
Let me just go over my notes here. Give me one moment. And did you leave him a voicemail saying that you never said he tried to run you over and that you wouldn't care if he did try to run you over?
Yes, I did at that time. And that was
Judge, can we approach?
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience.
Just waiting for everybody to get settled back in. All right, Ms. Cox, I'm going to play this voice message that you previously said that you left in a deposition. But you recall the deposition we had, right?
Yes.
And you said that was your voice message that you left that day shortly after, correct?
Yes, sir.
Okay, I'm going to play that, and let me know if that's still a true accurate representation.
And again, let me dumb that down for you too, you dumb fuck. And again, let me dumb that down for you too, you dumb fuck. I didn't say you did try to run me over. I don't give a fuck if you did run me over. I'm telling you, dumbass, that the fucking neighbors observed your behavior. And they called. You're a fucking idiot. I didn't say any of that. But you don't listen. Because your head's too hard other bitches' fucking pussies. Go to fucking hell. Get the fuck the far away from this you can.
Counsel, do you have a question?
Yes, sir, I'm waiting for her to get her composure back, Your Honor. I didn't want to.
So,
No, wait for the question.
Is that a true and accurate representation of the voice message that you left that day shortly after this alleged incident happened?
yes, sir.
Okay. And when you left that, he wasn't around you, was he?
No, but I did not know his location, and I did not feel safe.
Okay. Well, you were inside Miss Hamilton's house, were you not?
Yes, I was.
Okay. And my client doesn't have a key to that house, does he?
No, sir.
Okay, give me 1 second. Do you remember appearing at a deposition on September 22nd, 2023 at 10 a.m. at the state attorney's office?
Yes, sir.
Okay. Do you remember myself being there, the state attorney being there, and a court reporter?
Yes, sir.
Okay. At that time, were you sworn to tell the truth?
Yes, sir.
Okay. And did you tell the truth during the deposition?
Yes, sir.
Okay. Do you remember me asking you about him intentionally ramming the car, and your answer was no 3 times during the deposition? Do you remember that?
I remember that being a moment where I felt very attacked, and I was being sarcastic because I had already answered that he had attempted to ram me with a vehicle.
Judge, can I approach the witness with the deposition?
Stand sure.
Page 26. Actually, hold on a second. Yes, Mark. He says, okay, to approach the witness?
You may.
Have you look at this deposition, page 26, starting at 25. I asked you when we went to the ball field, he didn't try to ram your car or anything like that. And if you would, start at number, I think it's number 2, your answer, please. Wait, let me get back to the microphone.
Are you asking me to read that into the record or to read it just quietly?
Read into the record. Would you read that into the record, ma'am? When I asked you if you would ram the car or anything like that, what was your answer?
No, he would never ram his own car that is co-signed with another, and I was referring to at the ball fields.
Ma'am, I need you to finish reading.
So, okay, excuse me, with somebody else that he had an affair with while we were together, so no. It should have been titled together with E, yes, no, we would never do that.
So you said no, he would never ram the car 3 times at the moment question, correct?
At the ball fields is where you were asking me if that taken place, correct?
Right, it's still the same.
Ma'am.
Ma'am, no, she can ask you a question if she has one for you. So you said he would never ram his car that you were driving. 3 times you said no, that he would never ram his car, correct?
Sarcastically, yes.
Okay.
I didn't know how to answer you.
Just looking at my notes, give me one moment. Yeah, I think I'm just about done. Hang on. Ms. Scott, again, you're trying to specify at the ball field, but again, isn't it true that your answer said that he would never ram his own car that is co-signed with another? That was your sworn answer, correct?
When you asked me if did he try to ram me at the ball fields, I answered, no, that is correct.
Okay. That's all I have.
Does the state wish to redirect?
Yes, Your Honor, thank you. So Ms. Scotts, I think we just went over a little bit of confusion to that answer.
Yes,
Did he specifically ask you if you rammed the car while you guys were at the ball field?
correct.
Okay. Give me just a second. When you left that voicemail though, voicemail or voice message, whichever one it was, when you left that voice message, had you spoken to law enforcement yet?
I do not believe I have. I spoke to them, I wasn't certain.
Did you know Mr. Elizada's whereabouts at that time?
No, I did not.
Okay. And why would you leave a voicemail like that?
He was acting erratically. I did not feel safe, and I wanted to tell him what he needed to hear, do what he said. Until I knew the law enforcement had made contact with him.
Ms. Cots, were you in fact afraid for your life
Yes, I was.
when this incident occurred?
Yes.
Judge, I don't have any further questions for Ms. Cots.
Very good. Ms. Cots, you may step down. Is the witness excused?
Yes, Your Honor, the witness is excused.
Okay. Ms. Cots, if you don't mind, if you'll just stay around the courthouse in case we need you again. Ms. Sharpless.
Your Honor, the state's next witness is going to be Terry Hamilton.
Madam Clerk, would you please swear in the witness?
Please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please be seated, ma'am. Talking to that mic, please. Pull it right up to you. You can pull it right up to you. Very good. Counsel, you may inquire.
Hello, can you tell us what your name is and how it is spelled?
Terry Hamilton, and it's Terrihamilton.
Okay. Miss Hamilton, do you know an Erica Cots?
Yes.
Okay. How do you know Erica Cots?
I met her through a mutual friend a few years ago.
Were you with Miss Cots on July 26, 2022?
Yes, ma'am.
Okay. What were you doing with Miss Cots that day?
We were moving from one place to another.
On that same day, was there an incident between Ms. Cots and Anthony Elizada?
Yes, ma'am.
Okay. Can you tell us what happened?
Well, I don't remember if we were backing out or if we were leaving my place to go to my new old one, or if we were arriving, because we've been back and forth so much that day. But
Your old one, do you mean your old house?
yes, ma'am.
Sorry to interrupt
Sorry.
you.
But I was behind her. We were in separate vehicles, and when we were trying, we had decided we were going to take her car to the village supermarket and drop it off, and then she was going to get in my car. And he turned down the road and she was trying to go, and as soon as he saw her, he accelerated and was going towards her, so she had to swerve around into my yard to get away.
Okay. And you actually saw this?
Yes, ma'am.
Okay. So, can you explain to us where everyone was positioned again? Sorry.
Okay. She was right at the end of my driveway. I was behind her in the right-hand lane, and well, obviously, and then so he turned at the opposite end onto my road from the opposite end, and when he saw her, he started accelerating and driving towards her.
Okay. Was it a sudden acceleration? Is that why you said
it? It was
it?
an obvious acceleration.
Okay. Were there other obstacles in the roadway that made her have to swerve?
There may have been, because I have my neighbor across the street who had a boat out there. I don't remember. Sometimes it was in the yard, and their yard. Sometimes it was partially in the road. So I don't remember where that was, but that would have been probably the only thing.
Okay. Do you have any idea how fast he might have been going?
That he might have been going, or me?
Yeah, he might have been going.
It was over the speed limit, because it's a short little road, so it's only like 20 miles, supposed to be 20 miles an hour on that road. And, you could visibly see him accelerate.
Okay. After Miss Cots swerved into your yard, what happened?
She drove off, and I started to go down the road, and he met me right at my driveway. And so, as he was passing me, he said, I said I had called 911, and he said, on what grounds? And I just drove off.
Okay. Did you ever meet back up with Miss Cots?
Yes, it was a little while later.
Okay. So what occurred once you met back up with Miss Cots?
She had taken the vehicle to the ballpark near my house, and we got everything out of her vehicle and got it in mine, and then we went back to my house.
Okay.
My new house.
Did you ever have an interaction with any police officers that night?
Yes, they came to the house and got statements.
Okay. After you guys gave statements, did you have any other interaction with police officers, or do anything else in regards to this incident?
We were kind of keeping an eye on the car from my yard. There was a whole bunch of bushes there, so we could see the vehicle if we were behind the bushes, so nobody could see us, and we were just trying to keep an eye on that.
Okay.
That's about it.
How did the police end up making contact with you guys that night?
Well, they came by after I called.
Okay.
And they got the statements.
Okay. Give me just a second. Okay. Ms. Hamilton, is Anthony Elizada in this room today?
Yes, ma'am.
Okay. Where is he sitting and what is he wearing?
He's right behind you to the right, or to your left.
Your Honor, please let the record reflect that the witness has identified the defendant.
So noted.
Thank you. Give me just a second. I'm sorry. I'm looking over the notes. I don't think I have any other questions for you at this time, Ms. Hamilton.
Thank you.
Counsel, you may cross-examine.
Thank you. Ms. Hamilton, real quick, just to get this out of the way, the statement you gave was about an hour and 18 minutes after this alleged incident happened, wasn't it?
Mm-hmm, I guess.
Okay. So she wasn't backing out of your driveway, was she?
I'm not sure. I really don't remember.
Okay. Let me back up for a minute. Do you remember giving a deposition on September 22nd
I do.
of this year?
Yes, sir.
I was there. State attorney was there, and you were there.
Yes, sir.
Court reporter was there.
Yes, sir.
You swore to tell the truth.
Yes, sir.
Did you tell the truth that day?
Yes, sir.
Okay. Judge, can I approach the witness?
Yes, you may, but show the state what you're...
I'll give
First statement.
You may.
Thank you. Okay, I'm going to show you your deposition marked page 8, starting at number 13. I asked you, so she wasn't backing out?
And I said, not that I recall, no.
Okay.
But this is the same thing as...
We're going to get there. And he stopped his truck, did he not?
He did when he got
Yeah.
next to me.
He stopped his truck.
When he got next to me after he accelerated.
Right. So you weren't going the opposite direction. You were following her.
Yes, I was behind her.
Yeah, you're following her to your new house.
I'm not sure if we were coming or going from the new house.
Okay, hold on.
Going to the left next one.
Judge, if I can approach the witness. Actually, let me lay a foundation first. Ms. Hamilton, you wrote a diagram that day that I marked Exhibit A.
Yes, sir.
But I had you draw because it was a little confusing.
It is.
Okay, who was going where and what? And I asked you, you said, draw it for me. And I realized you weren't an artist. I thought you had to be an artist, but so we kind of take some of the confusion away. Would you agree with that?
Yes, sir.
Okay. And do you remember drawing that?
Yes, sir.
Okay. Can I approach?
Okay.
All right. I'm showing you exhibit that you drew, correct?
Yes, sir.
I marked as Exhibit A.
Mm-hmm.
And you have a little square that says Terry.
Yes, sir.
That's you, correct?
Yes, sir.
And you have a little box named Erica, and that's her and her car, is it not?
Yes, sir.
And you're behind her.
Yes, sir.
Okay. So you're not going the opposite direction, you're following her, correct?
That's correct. I didn't say it.
I understand.
I'm confused.
No.
Yeah, I'm confused.
I'm asking you though, you weren't going the opposite direction, you were following her by your little picture you drew.
Yes, sir. I was behind her.
Judge, can I submit this to the jury?
Are you offering that as evidence?
Yes, sir.
Your Honor, can we approach?
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com.
Tire pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Yes. And as you all are doing that, that is a piece of obviously physical evidence. You should consider this evidence as you do any other evidence and don't give it any more or less weight. And you will be able to bring this evidence along with other physical evidence back in the jury room with you.
If I can press clerk.
You may.
Won't you come back?
Very good. Thank you.
Thank you, sir. May I proceed?
You may.
All right, so, Ms. Hamilton, if you were behind Ms. Cox,
Yes, sir.
was your picture drew? You drew it.
Yes, sir.
So if you were behind her, how could you see my client coming down the road?
Because her car was not that big. My car's taller than her vehicle.
Okay. So you're saying you saw and heard the things you did even though you're behind her, following her to your house?
Yes, sir.
Okay, that's all I have.
The state wish to read, right?
Yes, Your Honor, thank you. So, Ms. Hamilton, a couple of things. How long after this incident was that deposition that Mr. Arrowwood just talked with you about?
Almost, it was a little over a year.
Okay. Or close to it, something like that. Okay. Do you remember writing a statement for the police the night of the incident?
Yes, ma'am.
And have you reviewed that incident prior, or that written statement prior to coming here today?
A couple of months ago.
Okay. Do you remember telling the police that she was backing out?
I don't remember telling them that, but
Okay.
it's possible.
If I showed you that statement, would it refresh your recollection?
Yes, ma'am.
Okay. Your Honor, can I approach the witness?
You may.
Ms. Hamilton, I'm going to approach you with this, if you'll read it, and then once you're done reading it, if you'll look back at that.
Okay.
I'm going to cut, Your Honor, may I approach
You may.
Ms. Hamilton, in that statement, do you say, when she and I started to back out?
Yes, ma'am, I did see that.
So, at this moment in time, are you just trying to be honest about the fact that it's a little fuzzy which one of those things was occurring?
I just don't remember because of the time, I guess because of the time frame, how long it's been, but
Yeah, okay. And that drawing, is it exactly to scale? Are you some sort of an artist, or were you just trying to give everyone a basic idea?
I was just trying to give everybody a basic idea.
So is it possible that you and Ms. Cox were a little closer to the driveway than the drawing shows?
Yes, ma'am.
Okay. And on that drawing, there were 2 boxes labeled Anthony. What was your intent with the 2 boxes? What were you trying to show?
Where she had, okay. I was trying to show where he was located when she had to swerve.
Okay. So you were trying to show where he was when he got to the street and then where he was when she had to swerve. Is that what you're saying? Okay. What kind of car were you in? Do you recall?
I was in it's an Accord MDX. It's a little SUV.
So an SUV.
Mm-hmm. Yes,
and what vehicle was Ms. Cox in?
a Camry.
Okay. And what vehicle was Mr. Elizada in?
A Toyota Tundra.
Okay. So you and Mr. Elizada's vehicles are bigger than the Toyota Camry Ms. Cox was in, is that correct?
Yes, ma'am.
Okay. I think that's... Do you have any guess for how close he actually got to her before she swerved?
No.
Okay. Was it close or far? Could you even...
It had to have been pretty close because, like I said, the road is really short.
Okay. Okay. Ms. Hamilton, that's all the questions I have for you.
Thank you.
Thank you very much. Is the witness excused?
As far as I'm concerned,
Is the witness excused, Mr. Arrowood?
Yes.
Okay, you're excused, ma'am.
Thank you, sir.
Would council approach just for a second? a few more witnesses before we go to final arguments. So if everyone will please stand, we'll recess for just maybe about 15 minutes.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Ferdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday seven days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. CNC Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. CNC Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestvew's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City.
Madam Clerk, would you please swear the witness?
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am, I do.
Please be seated. Talk to that mic for me, please.
Yes, sir.
Thank you. You can pull it right down for you. Counsel, you may inquire.
Thank you, Judge. Good afternoon. Can you tell us your name and how you spell it?
Yes, Elizabeth Roberts, Elizabeth, Roberts, Roberts.
Okay. And how are you employed?
With the Okaloosa County Sheriff's Office.
And what's your current rank?
Sergeant on patrol.
Okay. And how long have you been with the Okaloosa County Sheriff's Office?
Since May of 2008.
Okay. Do you recall an incident on July 26, 2022 involving Anthony Elizada and Erica Kotz?
Yes, ma'am.
Okay. How were you involved in that incident?
Initially, I responded to a call for service, at which time I made contact with the defendant, and then later I made contact with the victim.
Okay. How did you go from making contact with the defendant to making contact with the victim?
After speaking with the defendant, I was covertly kind of called over by the victim, at which point in time, once I concluded my conversation with the defendant, I went over and I spoke to the victim.
Okay. At the time that you made contact with the defendant, was that area just across the street from the house where the victim was flagging you down?
Yes, it was a very, very short distance.
Okay. And where was the victim when she flagged you down?
So the victim was kind of in the bushes on a piece of property that was adjacent to where I was when I made contact with the defendant.
Okay. And just so you can set up the area, you were with the defendant at a car, is that correct?
Yes, ma'am, at the Shalimar baseball field.
Okay. And across the street from the baseball fields is where this house is?
Yes.
Okay. Once you made contact with the victim, what occurred?
She immediately told me that she had been involved.
Please come forward.
Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Say to you that day?
She had advised when I first made contact with her that she had been involved in a situation involving her then, I guess now, ex-boyfriend.
Okay. And did she tell you the details of that incident?
Yes.
Okay. What were the details of that incident?
She explained that there was a disagreement over a vehicle. It was the vehicle that I made contact with the defendant earlier. As she was exiting the property on Fawn Lane, as she's backing out, the defendant basically gassed his vehicle and attempted to hit her while she was driving her vehicle.
Okay. And did you question the victim as to what her state of mind was when that incident occurred?
She explained that she was terrified and she was in fear for her life at that point. She felt that the defendant was going to physically hurt her.
Okay. Did you notice any physical evidence that corroborated that story at the scene?
Yes. The victim advised that when she was backing out of the driveway, she had to avoid the defendant, so she had to drive up onto the lawn on Fawn Lane, and there was a fresh tire track that I observed halfway on the lawn.
Okay. And were you able to take a picture of that?
Yes.
Your Honor, Sergeant Roberts, I'm going to mark an exhibit as states Exhibit 1. Your Honor, may I approach Sergeant Roberts with this exhibit after I show Mr. Arrowwood what I'm approaching? He's in here. All right. Sergeant Roberts, I'm going to hand you states Exhibit 1. Do you recognize that or make up it?
Yes.
What is that exhibit?
This is the photo I took on that day. This is the tire track that I observed in the grass area.
Okay. And is that a true and accurate representation of the photo that you took at the time that this incident was reported to you?
Yes.
Okay. Has it been edited or altered in any way?
Just printed off. This is just hard copy.
Your Honor, at this time, I would admit State's Exhibit 1 into evidence.
No objection. Without objection, the court will admit State's Exhibit 1. Do you wish to publish it with the jury?
I do wish to publish it.
If you wish. Well, you can give it to me. Thank you.
And can I have a moment of co-counsel, just a quick second?
You may continue.
Thank you. So Sergeant Roberts, when you met up with defendant in reference to that call for service, what you said he was with a car, is that correct?
Yes, he was.
What kind of car?
It was a white four-door, I believe a Corolla or a Toyota four-door sedan.
And Sergeant Roberts, is Anthony Elizada, who you made contact with that night, in the room today?
Yes.
Okay, where is he sitting and what is he wearing?
He is wearing a dark suit. He is sitting at position 5 at the table.
Okay. Your Honor, please let the record reflect the witness has identified the defendant.
Court so notes.
Thank you, Your Honor. Those are the only questions I have for Sergeant Roberts.
Counsel for the defense.
Thank you. Sergeant Roberts, you're saying that she said she was in fear, correct?
Yes, sir.
Did she say she was in fear when she was looking out the bushes?
You mean when I made contact with her?
Yeah, well, she was out in the bushes before you pulled up, because she was watching the vehicle, my client's vehicle, correct?
I believe so, yes, sir.
Was she in fear when she was in these bushes looking at his vehicle?
Sir, I don't know.
Okay. Did she say she was in fear when she got out of the vehicle at the ballpark and handed the keys over to my client?
No, sir.
And the time you talked to her was about an hour and 18 minutes later from the alleged incident, was it not?
I'm not sure exactly the time frame.
Over an hour.
I'm not sure.
Would it help you if you looked at your notes that you have in front of you? The time it was received, the time it was dispatched, and the time that you arrived?
I spoke to the defendant when we received the call. I was called into the sheriff's office, at which point in time I spoke with him. I'm not sure exactly how long. And then once the conclusion of us speaking was when the victim got my attention.
Okay. All right. So you don't, what you're saying then is you don't know exactly how long it was been?
Correct. Yes, sir.
Okay, hold on one second. That's all.
Okay. Thank you very much. Anything for Sergeant?
Your Honor, I don't have any other questions for Sergeant Roberts.
Thank you, Sergeant. You are excused. And is she excused from the, she doesn't have,
Yes, Your Honor, is that from the state's perspective?
Yes, Your Honor.
okay. You do not have to stay around. Thank you. Ms. Sharple,
Your Honor, the state has no other witness. The state rest.
stay rest. Does the defense wish to call a witness, or do we need to take a break?
Short break, Your Honor.
Okay. We're going to take a short, this won't be long, I promise. Short break, we're going to come back. Please rise.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m.
I did advise him that he has that right, and that's up to him, but the court would like to inquire as to that's his decision.
I would. Mr. Elizalda, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so just Just want to make sure that your decision not to testify here today that's been offered by your attorney is free and voluntary with knowledge. So just want to make sure, first of all, have you spoken with your attorney regarding your testimony and the pros and the cons from a legal perspective or a strategic perspective as we sit here today? Have you talked with him about those things?
Yes, sir.
And you do understand you have an absolute right not to testify, and that you've heard me already give a preliminary statement concerning the law as it relates to that, and I'm going to say it again, that it will not be held against you, that you're not testifying here today. But you believe that's in your best interest, and you believe you're entering into this decision knowingly?
Yes, sir.
Okay. Any further questions, counsel?
No, Your Honor, with that, no, we wouldn't have any evidence other than the argument presented, so we would rest as well.
Okay. So, we will go ahead and be ready, bring him back out and do closing.
I think that's fine, Your Honor. I don't remember how we had, what option we picked. Does the court have the instructions on the law? Because I think those are read. Then we do the final instructions.
Yes.
Do we need to finalize the rest of the jury instructions before we bring them out? Do you want
Yes, we do.
Okay.
I just thought we had agreed to them, but you're right. We do need to make a final on the record statement. So, you gave me a pack of these earlier. Introduction to final instructions, statement of the charge, when and where there are lesser crimes, aggravated assault, lesser included offense, assault, plea of not guilty, reasonable doubt and burden, the weighing of the evidence. There was some statements as it relates in here that may or may not be applicable in weighing. Do you all have that before you?
I do, Your Honor.
Okay.
Yes, Your Honor.
So, number 6, has the witness been offered any money, preferred treatment, or other benefit? I'm assuming that goes out.
Correct.
That's
Yes.
not given. And then number 7, had any pressure or threat been used against the witness to affect the truth? No testimony as it relates to that, out. Did the witness at some time make a statement that is inconsistent with the testimony she gave in court? That would stay in.
Yes, Your Honor.
That's clearly a question in this case. Has the witness been convicted of a felony, misdemeanor, false statement? I don't believe there's any testimonies related to that, so that comes out. And number 10, does the witness have a general reputation for dishonesty, truthfulness? That also has not come into evidence, so that's an out.
That's correct.
Okay. And then the other red, give only if the defendant testified,
That can come out.
and that comes out. And then, so the defendant not testifying, that would obviously stay in. The rules for deliberation, there were a couple of questions points that were not finalized, that were in red. Rules for deliberation. Number 7, jury is not to discuss any questions that a juror wrote. There are no juror questions, so that's not applicable, correct?
Correct.
And then number 8, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict should be based on the evidence. That's standard. That needs to stay in.
That's fine.
Yeah, I don't know why that's even a question. Okay, and then we've got cautionary instructions, and then the verdict. These are all these that I've identified with the titles are all standard instructions, submitting case to the jury, and then the actual verdict form. The only question I have is, how are we going to get this set with the final instructions we made? I'll be able to read them, right now. But
I can I will make copies for the jurors, Judge, if you want them to have a copy while you're going over it.
yeah,
Yeah, if you can do that. There was one that I was. And Your Honor, just so y'all know, when I was reviewing them, I think that when their lesser included crimes should go after the aggravated assault.
okay, hold on a second. Correct.
But before the instruction on assault?
Before the instruction on what?
Assault,
Correct.
yeah.
Do you understand what she's saying?
Yes.
Because before I had them before both of them, and I realized that
That's a good.
that was
good
about
point.
as clear as mud, the way it was ordered.
So I'm going to go over once more. I'm going to just give the titles. The introduction to final instructions,
Yes, sir.
statement of charge, aggravated assault, that's all the definitions of that. When there are lesser included crimes, the lesser included offense of assault. And then the next is the standard instruction regarding the plea not guilty, reasonable doubt, and burden of proof. The weighing of the evidence with the finalized few little items in that were agreed to. And then the defendant not testifying will be provided in full. Minor change in rules for deliberation excluding number 7. And then cautionary instruction, the verdict. And then after the closing arguments, the standard jury instructions on submitting the case to a jury, and we'll provide. We're going to read. We'll do the. Yeah, we'll do the verdict. The verdict form will be with the final instructions.
Correct.
And then all we're going to do on the submitting the case is just that one jury instruction. Is that correct, Mr. Arrowwood?
Oh, I'm sorry, Judge, I was reading.
No, I just wanted to make sure that the verdict form is the last thing on the final jury instructions prior to closing. Then you'll do closing, and then the single standard instruction on submitting to the jury.
Yes, sir.
Is that your understanding?
Yes,
Okay.
and so we need 10 copies of the instructions. How many copies do we need? 7, 8, 9. Yep, 10. Okay. You want one for both of you, or you want? Oh, I counted you guys. 7, 8, 9. Yeah.
1, 2, 3. One for the clerk and 7.
Just do
Actually,
like
when it
12,
goes back,
recycle.
Be 6 probably.
it'll only be 6, but we'll get 7 because we're not going to let him know he's being discharged until just before we go in. Well, actually, at that point, it'll be before they're actually given these instructions. Okay, so are we ready for the jury? For the,
Oh, he's going to make copies, Your Honor.
I can read off of what we've got, and then we're not going to have them. We don't need to give them to them while we're reading it to them, do we, Mr. Arrowwood? Do they need to have them while we're reading them to them?
No, sir.
I mean, it's just when they go back that they have to have them. So we can go ahead and bring them out and go ahead and begin reading the final instructions. Okay?
Okay.
All rise for the jury.
Please be seated. Ladies and gentlemen of the jury, during the break, the defense announced that the defense has rested. And so prior to the state and the defense making closing arguments, the court is going to provide the final jury instructions. And these jury instructions, please listen closely to these, but you will receive each of you will receive a full set of these jury instructions that I'm reading out right now. They have some technical definitions and legal things inside that you might want to refer to when you go back. So, let me just begin by again thanking you for attention during this trial, and please pay attention to the instructions that I'm about to give you. The statement of charge. Anthony Elizalde, the defendant in this case, has been accused of the crime of aggravated assault with a deadly weapon. Aggravated assault. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. Number 1, Anthony Elizalde intentionally and unlawfully threatened, either by word or act, to do violence to Erica Kotz. Number 2, at the time, Anthony appeared to have the ability to carry out the threat. Number 3, the act of Anthony Elizalde created in the mind of Erica Kotz a well-founded fear that the violence was about to take place. Number 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Erica Kotz may be found to have been in fear, and actual fear on the part of Erica Kotz need not be shown. A quote-unquote deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. It is not necessary for the state to prove that the defendant had an intent to kill. Where there are lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes indicated in the definition of aggravated assault with a deadly weapon are assault. The lesser included offense of assault. To prove the crime of assault, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Anthony Elizalde intentionally and unlawfully threatened either by word or act to do violence to Erica Kotz. Number 2, at the time, Anthony Elizalde appeared to have the ability to carry out the threat. Number 3, the act of Anthony Elizalde created in the mind of Erica Kotz a well-founded fear that the violence was about to take place. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have any abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case was decided? Number 5. Does the witness's testimony agree with the other testimony and other evidence in the case? Number 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than any of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number four, remember the lawyers are not on trial. Your feelings about them should not influence your decision in the case. Number five, your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number six, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. And number seven, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form, for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. So I'm going to read the verdict form to you, and this also will go back with you. And it's titled Verdict. We, the jury, find as follows, as to count one of the information. And then in parentheses it says, check one only. You've got A, you've got a line next to it, so you can check. A is defendant is guilty of aggravated assault with a deadly weapon. Next line, B, with a line next to it that you can check. The defendant is guilty of assault. And the third line, line C, also with an area you can check. The defendant is not guilty. So say we all, this 30th day of October 2023. So, and I will make some very a brief remark right after the attorneys make their closing statements before you all retire to the jury room for your discussions. So with that, I would ask the state if they are ready for their closing statements.
I'm sorry, Judge, give me just a second. All right. All right. Good afternoon again. As we've been saying all day, this is the state of Florida versus Anthony Elizada.
Please speak into that mic for me.
Sorry, Judge. And again, I really appreciate you guys being a part of this process. Again, it's the most important part of this process. So, Mr. Elizada, sorry. We're doing this without the podcast. Mr. Elizada has been charged with aggravated assault, which, as the judge just instructed you, is intentionally and unlawfully threatened either by word or act to do violence to Mrs. Cots. And that's the first part. So, intentionally and unlawfully threatened either by word or act to do violence. What evidence did the state present today that that element has been met? You heard the testimony of both Mrs. Cots and Mrs. Hamilton, who explained to you that the defendant floored the truck towards Mrs. Cots and did not slow down until Mrs. Cots swerved. You saw the picture that Sergeant Roberts, you heard the testimony of Sergeant Roberts, and you saw that Sergeant Roberts took a picture of the tire marks inside of the grass. Again, we'll talk a little bit later. I'm going to have a chance to talk with you again after Mr. Arrowwood talks with you. Talk a little bit later about some other testimony, but that element is how the state, those things are how the state has proven that element. The second part of the aggravated assault statute, which Judge just read to you, is at the time Anthony Elizada, the defendant, appeared to have the ability to carry out the threat. He was in a vehicle. A vehicle can be a deadly weapon. The judge read you the instruction for deadly weapon, and I'll read it again. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. But it goes on to also say, an object not designed to inflict bodily harm may nonetheless be deadly if it was used or threatened to be used in a manner likely to cause death or great bodily harm. There's a reason that we don't let people drive until a certain age. There's a reason we make people take driver's tests. It's because car accidents and cars in general can do great bodily harm to people. And you heard the testimony of Mrs. Cots that he appeared to be able to do violence with her, to her, with that truck. The act of Anthony Elzada, the defendant, created in the mind of Erica Cots a well-founded fear that violence was about to take place. She testified that she was in fear. Sergeant Roberts testified that she told her she was in fear. And again, consider that the instructions also told you that if the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, that Erica Cots may be found to have been in fear. And actual fear on the part of Erica Cots need not be shown. The state doesn't even have to show actual fear according to that on the part of Ms. Cots, but the state did show that to you today through Mrs. Cots' testimony, through Sergeant Roberts' testimony. And again, as we've already spoken of, the assault was made with a deadly weapon. Again, a truck can be a deadly weapon under the definitions that we just gave to you. Has been explained to you that it can be used as a deadly weapon because it was used or threatened to be used in a manner likely to cause death or great bodily harm. Again, there's a reason that we make people get driver's license, and motor vehicle accidents can kill people. Again, through this, the state has proven, the state believes has proven its case here today, and ask you to render a verdict of guilty in this matter.
Defense wish to make a closing statement.
Yes, Your Honor. Please, the court, counsel. Well, ladies and gentlemen, thank you for your time and your attention in this manner. As the judge read you the instructions that you're bound by, all of us are bound by, that reasonable doubt comes in several forms. It comes in the evidence, conflict in the evidence, and the lack of evidence. And let's go over some of that. It's interesting that Ms. Cots said that she was backing out. Ms. Hamilton, if you recall, I had to draw a picture, or had her draw a picture, I should say, and put in evidence that Ms. Hamilton was going the opposite way. She wasn't following her. She wasn't following her. And did you all kind of catch where she said, well, I was in fear, but yet I parked at the ballpark and got out and started getting stuff out of the trunk. So does that make sense that if you're in fear for somebody was just about to hit you with a car, you're going to park just a short ways and just get out the car and start getting your stuff? What's also interesting is if she didn't tell him where she was going, she said she didn't, how would my client know where to go? She could have just drove off and went to Pensacola, could have went to Panama City, could have went to the sheriff's office, could have went anywhere. No, she went to the park. She told him, I'm headed to the park. Parked the car and got out. Does that sound very reasonable what somebody would do if they were in fear? They'd get out the car and start getting the stuff out? And then again, Ms. Hamilton, I was kind of confused a little bit in the deposition, so I said, why don't you draw us a picture? Because Ms. Cots testified before during the deposition, Ms. Hamilton, and she testified today on the stand that, again, Ms. Hamilton was going the opposite way. So I said, wait a minute. Ms. Hamilton, are you sure you're following her, behind her when you saw this? Yeah, I was behind her. So that's definitely in conflict. And again, both of them testified, including the sergeant, that this is a very, very short road. Very short road. So I don't know how you're going to gain speed If you just turn on the road and it's less than 10 seconds, I think they admit it to the ballpark. And if you also noticed, I asked her that she was upset that she had to return the car to him that she paid for. I think she said, testified earlier, she admitted that, well, she had to pay more than half for something or another. And I asked her, well, what about did you send him some ugly texts, a mean text? Oh, yeah. I sent him. Well, did my client reciprocate? Did he send any of that? Nope. Okay, well, at the ballpark, did he threaten you? Nope. Did he say anything? No, he didn't. So I submit to you, ladies and gentlemen, that doesn't make any sense. But what she did do, and my client didn't reciprocate in the same manner that she did, she left this voice message, and I'll play it for you.
And again, let me dumb that down for you too, you dumb fuck. I didn't say he did try to run me over. I don't give a fuck if he did run me over. I'm telling you, dumbass, that the fucking neighbors observed your behavior. And they called. You're a fucking idiot. I didn't say any of that. But you don't listen. Because your head's too far in other bitches' fucking pussies. Go to fucking hell. Get the fuck the far away from me as you can.
Does she sound like she's in fear? Nope. All these neighbors calling. Wasn't no neighbors here. Wasn't any witnesses here other than Miss Hamilton, her friend, and Miss Cox. Again, my client, let me get back to that for a moment. And although Ms. Cox tried to clarify that she was being sarcastic when she was asked under oath at the deposition, so he didn't ram the car at the ball field. No, she answered no 3 times. No, he would never do that with the car he had titled with somebody else. No, he would never do that. She made that pretty clear. Well, if he would never do that, then he would never do it on Fawn Lane. He would never do it at the ballpark. Never includes everything. No, well, I was being a little sarcastic when he said that. When I said he'd never do that. In the jury instructions and weighing the evidence, when I first started just 23 years ago, I think it was, I read that in my first jury trial is if you don't have an abiding conviction of guilt, but one in which wavers and vacillates. I hate to say this, but I was like, wavers and vacillates? Like, what kind of word do you use those words? What's wavers and vacillates? So maybe you're smarter than I am, but so I kind of looked it up. I'm like, well, this is kind of legal stuff. Wavers and vacillates means, maybe not. Well, what about this? Well, what about that? That's wavers and vacillates. And again, these instructions that the judge read you, and I didn't make these up. It's the law that you have to follow. I submit to you, I think there's 5 times in here it says it. My client, you have to perceive my client is innocent unless it's been overcome to the evidence and to the exclusion and beyond a reasonable doubt. Beyond a reasonable doubt, ladies and gentlemen. I submit to you, I could keep going on. But you heard the evidence. You heard her tone in her voice when she left that message. You heard how she was messaging my client, and he wasn't reciprocating back with any words like that, or text messages like that. I submit to you, after carefully weighing and considering the evidence, that you return a verdict of not guilty in this case. And let me go one step further. As a young prosecutor, when I first started, I had an old judge, retired now, tell me that if the state's proven a case beyond and to the exclusion of a reasonable doubt, then there's nothing to talk about. There's nothing to talk about. Go back there, pick a foreperson, raise your hand guilty. Let's call it a day. Let's call it a day. But if you have something to talk about, that's reasonable doubt. And I submit to you, there's a lot to talk about in this case. Thank you.
Does the state wish to?
Yes, Your Honor, thank you. Y'all, one of the things that the judge just reminded you of when he read you the instruction was that the jury instruction literally says that you can use your common sense when you go back to that room. Mr. Arrowwood and the defense point out many things that they want you to focus on because they say that it's reasonable doubt. And there are some things in this case that this state wishes that Ms. Cots hadn't made that voicemail. But you know what we're dealing with in this case? We're dealing with a group of human beings. A person who has been put through an incident where she felt like her life was in danger. And you can hear her say that in that voicemail at the end. She said, literally tells him to leave her alone. Now, Ms. Hamilton and Ms. Cots don't always agree where they were coming from, if they were backing out, or if they were pulling in, and they don't agree where they were going to take the car to. But you know what they do agree on? That they were going to leave the house with the car to give that car back to the defendant, and that the defendant drove the truck that he was in towards Ms. Cots, forward, and they both used that term, forward it. We all know what that means. Use your common sense. Forward it means he pressed on the gas, and Ms. Hamilton said, I couldn't tell you how fast he was going, but I know he was going faster than the speed limit on a residential street. Mr. Arrowwood keeps using deposition testimony and keeps playing voicemails because he wants you to focus on the fact that she's, using curse words and using foul language, and he says she doesn't seem in fear. But you heard Ms. Cots. She said, I was concerned for my safety. The police had not, to my knowledge, made contact with him. I had to say that. Mr. Arrowwood wants you to focus on the fact that she made a quip at him at depositions, that he asked her specifically at the beginning of his question at depositions, did he ram the car into you at the park? She answered no to that question. You know why? Because it didn't, first of all, the state hasn't charged him with ramming the car into Ms. Cots. The state charged him with aggravated assault. His actions created fear in the mind of the victim that great bodily harm or death was about to come to her. That's what the state charged him with, not ramming the vehicle. So, in a way, she's right. No, he didn't ram his vehicle at her. The state hasn't charged him with that, and the state didn't make that allegation today. And again, some of the facts are fuzzy, but you know what? I submit to you that some of that does go to the credibility of these witnesses. We're dealing with two people who are recalling minute details from a scary incident they've been through. over a year later. Especially Ms. Cots, who had the car driven specifically at her. Some of the facts are going to be fuzzy, but you know, again, what they agree on is that the defendant was the one who drove the car at Ms. Cots. No one ever said Ms. Cots started it, told him to ram the car at her. No one ever said that. There's no evidence of that. Ms. Cots is not the aggressor. The defendant chose intentionally to floor his vehicle at Ms. Cots and create fear. And you guys saw her today. You can judge her credibility, whether you believe from her testimony today, whether she's telling the truth that she really is in fear and she had to leave that voicemail, or whether at depositions she felt attacked and was getting, admittedly, a little quippy with Mr. Arrowwood. And again, there's a bunch of distractions. Don't be distracted. The defense wants you to be distracted by the fact that it wasn't him texting her, it was her texting him or calling him or leaving him voicemails. That has nothing to do with the offense that's been charged. Nothing to do with who texted who first. It has nothing to do with the offense charged. You know what? Maybe he didn't text her. You know why he didn't text her? Because he was busy driving a car at her, putting her in fear for her life. The state has charged that he intentionally and willfully drove that truck at her, causing her to be in fear for her life. So when you go back to that room, please, I welcome you to take your common sense with you. Think about if the things that the defense wants you to get hung up on are reasonable to get hung up on. Think about the explanations and other testimony that you heard. Think about the fact that, again, the instructions tell you when you're weighing the credibility of a witness, one of the things is, was the witness honest and straightforward in answering the attorney's questions? That's precisely what you saw today, Ms. Hamilton. I don't know if we were backing out or pulling in. I don't know. And then when she's pressed about whether she really saw the defendant flooring that truck at him, her story is identical to Ms. Cott's. And then you couple that with, does the witness testimony agree with other testimony and other evidence? Well, the other evidence is Sergeant Roberts found tire marks in the yard, which corroborates those stories. She took a picture. You have that picture. You can look at it when you go back to the room. So many distractions. Again, Mr. Arrowwood talking about, why didn't she just drive away? When you heard the victim, she had to get to the nearest place. That's what she could think to do. Get to the nearest place, get her stuff, and go. Again, there are some elements that are fuzzy. However, when Ms. Hamilton is pressed about, which way were you going? Were you following her? Could you actually see what happened? Again, she explained to you how she knows she could actually see what happened. She explained to you the size of the vehicles. She explained to you exactly what she saw. Mr. Arrowwood wants you to think that this is about the car. Is it really about the car? Use your common sense and think about the fact that if it was really about the car, why would she just say, forget it. Have the car. Here's the car. Take the car. I'll leave it here. Use your common sense. Think about the evidence and how some of these things are just distractions. Think about what the state has actually charged the defendant with. And state submits to you that what the defendant has actually been charged with has been proven here today, and asks you to render a verdict of guilty. Thank you.
Thank you very much. Ladies and gentlemen, in just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors may communicate about the case only with one another and only when all the jurors are present in the jury room. Therefore, if a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about the case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take a few minutes. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. I may bring you back in to explain it orally. And then we have 2 exhibits, correct? And those 2 exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There is no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules we all share. Now, when you go back, while they were making their closing statements, they were printing off some copies with the final details of the jury instructions. So we're going to send you back, and we just need to confirm that the copies are all accurate. And within 5 minutes, we're going to bring back. Each of you will have a copy of the jury instructions, and there'll be only one verdict form, because you only got to all be unanimous when you come back. So one final thing that this is actually one of I always feel a little bad about this, but when we pick a jury, it requires, to have a felony in the state of Florida, requires 6 jurors. And we always pick an extra juror in case something happens to somebody during the day, particularly if it's a multi-day trial, but even when it's a one-day trial. So one of you all was the alternate. So at this point, Mr. Schoeneman, who's Mr. Schoeneman? Mr. Schoeneman, I always feel bad because, you all have been excellent jurors. You've been very attentive, I can see that. And these are not simple cases. They're complicated, and you all take them seriously. And always feel a little bad about having to not dismiss you, but let you off the jury. You're welcome to stay around, catch the verdict. Most people want to get out of here and go home. But we do have a copy. What do we have? Okay. It just shows that you were here if you need that for anything. So again, thank you very much for your service. So Mr. Schoeneman is excused, and the other 6 jurors are, may go to the jury room for deliberations. So, one last time, or at least one more time, please stand for the jury. And you all may bring back your, you may bring your notebooks with you. Thank you, counsel. Okay, just want to make sure you all see the copies.
Yes, sir.
That they're accurate.